Okay. All right. Why don't we get started then? My name is Brian Riley. I'm an attorney with KP Law, your town council. Some of you may have even seen me last week in Leominster when a partner and I were talking about the new public records law taking effect in a couple of months. But I was asked to come up here tonight and talk a bit about sort of conducting public meetings and public hearings in general. So, you know, all boards do that, obviously. And so I am going to touch on some open meeting law issues and a couple of public records issues just because they're so wrapped up in conducting any meeting. If you have a question as we go, you know, put up your hand, and I think we'll take them as we go rather than save them to the end. I think that works a little better.
If you do have a question, we request that you use the microphone. We have 2 hand mics. This meeting is being recorded. We are going to record this. It's going to be publicly more or less available, so just wanted to let everybody be aware of that. Also, we are in an official public meeting here.
And I can call on my lovely assistant here, the Honorable Carolyn Smart. She has a microphone. Just so you know, before we start, even though all of your board may be here, actually one of the exceptions to the open meeting law is it's not a meeting if you're here, if you're together for training purposes and not doing board business. So you don't have to worry if you didn't post it. This is our typical legal disclaimer. I would say that you know, any of these questions as we go along, particularly with open meeting and public records, you know, the particular facts of a situation can really change what the answer is. So, you know, I'm going to kind of hit the general points here. But, you know, if you do have any particular question come up, you know, hopefully this will be helpful. Maybe some of the handouts from the state offices are helpful. But the particular facts of a situation are important. So why are we doing this? Well, these are good issues to get refreshed on, or maybe you're new to a board and you're not as experienced in these things. The open meeting law is very important for all multi-member boards. Public records as well. You may have some administrative staff who kind of handle that part of it, but it's good to understand, particularly with the changes that are coming, again, in a couple of months. There's always a lot of scrutiny from both the public and the media. You know, if you've been on a board for a while, this is no surprise to you. There are people out there watching, wanting to make sure you're doing everything on the up and up, and that can cause kind of some nervousness and pressure. But I think the more you know about the process, perhaps the little easier it can be. And as I say, it's not just an open meeting law issue. I am going to hit some of the parts of that, but not going to go through everything that we typically do on an open meeting law training. But we'll talk about some of those that relate to meetings and hearings. So we'll start with the open meeting law, which is in Chapter 30A of the general laws. And there is, if somebody thinks you have violated the open meeting law, there's a complaint process. They will put it in writing, serve it on the board. You have 14 business days, so it's almost 3 weeks to come up with a response. So your board does need to talk about it, acknowledge that you received it, and either with our help if needed, or with the Attorney General's office. They also have a legal staff. Figure out whether you think you did violate it or not, and put a response together. And the office, the Division of Open Government, which is a division of the Attorney General's office. You can find their answers to complaints online, and they cover all sorts of things. You know, the content and the form of the meeting notice, or the agenda that you have to post. Did you post it on time? The contents of minutes, how quickly minutes are available to the public, and well, all sorts of other things. But we'll start with that. So your meeting notice, if it's somebody on the board, or again, perhaps you have a staff person who's in charge of this, but it's very important that the notice get posted properly. It has to be posted timely, at least 48 hours before you conduct the meeting, and that cannot include weekends or legal holidays. Can you prove it was posted on time? Occasionally you get a complaint where someone says, I don't think this meeting was posted on time, I looked the day before and it wasn't there. If it was, in fact, filed with the clerk's office and put either on the bulletin board or on the town website, you need to be able to prove that in response to the complaint. Is it in the correct location? Is the town website the place where meeting notices are available 24 hours a day? That's one of the requirements of the law. Did it contain enough detail? Was it just really a few words and not explaining what matters, what applications were going to be dealt with? So was it detailed enough? And did it mention whether an executive session is planned? If you do plan to have one of those, which is the times when you can have a meeting behind closed doors, you have to have a particular cite to the section of the open meeting law that allows the executive session, whether it's to discuss litigation strategy, you're talking about value of property that you might want to buy or sell, maybe it's a personnel issue. You need to cite the right section and put in as much detail as you're required to. Minutes as well, also very important, and also seem to generate a lot of complaints. Some boards aren't as good as others at turning them around and approving the final version quickly. The Attorney General encourages boards to have the final version ready to be approved at the next meeting. That's not always possible. And it's not actually a requirement of the law, but if you get to be a couple months late and somebody is asked for them and you don't have them, the AG may say you're not complying with the law, you're not approving them quickly enough. Minutes, they need to have enough detail in there so that someone who wasn't there can get a general idea of what the discussion was like. It never has to be an actual transcript of the meeting, however. Your meeting notice, some of this may be old hat, but the meeting notice has to have the date, time, and place, obviously identify what board having the meeting, and a listing of the topics that the chair reasonably anticipates will be discussed. It is possible to talk about something which comes up at the last minute, maybe even somebody in the audience brings it up and the board might want to talk about it. If it wasn't reasonably anticipated by the chair, you can talk about it. If it should have been on the agenda and it just got left off by mistake, for example, best advice is don't deal with it, put it on your next meeting agenda because that's not a last minute issue. And the listing on the notice should have enough specificity to anybody who's looking at it online will have a general idea of what it's going to be about. Or let's say it's a liquor license hearing. Well, there should be the name of the applicant and the location where they want to use this liquor license. That's the sort of detail that is encouraged to be included. Okay. So the posting requirements, as I say, every meeting notice needs to be filed with the town clerk and also posted in a manner that's available, that the public can look at 24 hours a day. In some towns, that is done by let's say, a bulletin board that's lit and is outside the front door. A lot of small towns, some small towns still don't have websites, although that's becoming less and less frequent. Posting on a website is acceptable. Perhaps not everybody has access to the internet yet, but the Attorney General has said if that's your 24-hour method, that's fine. The AG recommends that, again, this is part of making the agenda both have sufficient detail and understandable. Your board might know exactly what HUD, CPD, HOME means because you deal with it all the time. Well, not everybody does. And people in the public may want to get an idea and decide whether they might want to come or not. And so the AG has said that should be spelled out, Department of Housing and Urban Development, Community Planning and Development, Home Investment Program. Executive sessions, as I mentioned, one of the purposes that you can use it if it's a personnel issue, maybe a complaint's been filed against a town employee, and the board can go into executive session and talk about that, but you can't just put personnel or union contract negotiations, you have to identify what union you're talking about, you're negotiating with or strategizing about. If you're considering purchasing real estate, you should put where that real estate is, unless that would somehow, jeopardize your negotiating position. Maybe it's really early in the game on that. That might be one excuse for not identifying the particular real estate. Again, with the 48 hours, if you're going to meet on a Monday, notice has to be posted by the end of the day on Thursday. If there's a holiday, you got to take that into account as well. As I mentioned, you need to be able to show when your notice was posted in both locations, because if it's not 48 hours ahead in both locations, it's not considered posted on time. Sometimes your board might be dealing with a matter and it gets to be 11 o'clock and you'd like to adjourn and come back the next night. You can't, because that's not considered, under the open meeting law, it's not considered a continuation of the same meeting like it is for a town meeting. The only way you can do that is if you've planned ahead and posted the next night 48 hours in advance. And also, posting notice under the open meeting law is certainly very important, but your board may have other kinds of posting or notice requirements. This doesn't take the place of them. You have to do both. The land use boards, zoning board, may need to send out notice to abutters and put a notice in the newspaper 2 weeks ahead, that kind of thing. That all has to be taken care of as well, in addition to the open meeting law. I won't read through all this. This is one of the determinations that's on the Division of Public Records, the Division of Open Government website, and it just talks about this issue of putting enough information in the agenda so people, particularly people who aren't used to coming to meetings and might not realize what goes on and what matters they might be interested in. They need to be able to see and figure out what it is, where it is, and decide whether they might want to come. This is one particular determination from a few years back that said if a public body posts a notice, realize that perhaps they didn't spell out the acronym or for some other reason it's not as clear as it could be, you can go in and update it and still not necessarily have to start your 48 hours all over again. The AG also says that, let's say the day before you learn about something which wasn't anticipated and you'd like to talk about it. Can you do that? Yes, you can, as I mentioned, if it wasn't anticipated before. But the AG would say, well, if you find out about it the day before, if at all possible, amend your meeting notice today, so at least there's 24 hours notice, for example. As much as you can do to keep the public informed about what's going to be going on. This is pretty much repetitive of what I just said, but this is from the Division of Open Governments. They have an FAQ section, and this was one about adding, talking about something which wasn't on the meeting notice. It's another good, actually, thing to look through. Their website is getting pretty good, pretty detailed now. A few words about minutes. Date, time, and place, members present and absent, a summary of the discussion on each subject. Like I say, it doesn't have to have everything, but it needs to be enough in there so someone who wasn't there can figure out what happened. And all votes need to be recorded. You've probably never even thought about doing this, but a board, a municipal board, cannot take a secret ballot. You can't have a secret vote. You need to vote, just by saying aye or nay is fine, but it has to be in open session. Roll calls are required if a board is going to vote to go into executive session. That has to be by roll call, and any vote taken in executive session has to be by roll call. So that will end up being recorded into the minutes of the executive session, those roll call votes. It's another quote from what the AG's office says about someone who wasn't there can figure out, if they look at it 6 months later, they can get the general idea of what was discussed. Okay. As I mentioned, the statute only says that minutes shall be created and approved in a timely manner. Well, that doesn't really tell you anything. But the statute also does say if somebody makes a request for them, they should, if they're available, obviously they're entitled to get it. They're public records, at least for all open sessions. They're always public records, even in draft form. If minutes have not been approved, they should be made available within 10 days or approved at the board's next meeting. It's just kind of a good practice to the extent you can. If you have someone who can prepare the draft, let the members look at it, come back to your meeting and make any corrections that are necessary, approve it, and then you're done. The open meeting law also requires that in addition to the minutes, which obviously is a record of that session, that meeting, that any documents or other exhibits used by the body at an open or executive session shall, along with the minutes, be part of the official record of the meeting. So you may have 10 or 20 different documents that you actually, as board members, you had in front of you, you talked about, you referred to them. Those are considered records of the meeting. They need to be kept. They're not literally part of the minutes, but they need to be maintained somehow, and if it was used in an open session, pretty much generally they're going to be public records as well. Perhaps some exemption might apply, but for the most part, they'll all be public as well. So those, you need to be able to lay your hands on those if somebody makes a request for them. This is how the AG has interpreted that phrase, used by a public body. If the document was physically there, in other words, the board members had it, if it was verbally identified and the contents were discussed. If it may be something that, let's just say it was a draft of some document and the board members had it, but you never actually got around to it. Well, then technically you didn't use it at that meeting. Maybe you will later, but that would not necessarily have to be maintained with the other ones which were actually discussed. Executive session minutes. The general rule is that those are not public records. You don't have to turn them over if somebody asks for them, if the purpose for the executive session is still ongoing. So if one reason that happens a lot is if your board has a lawsuit going on, you issued a permit and somebody appealed from it. You can meet in executive session to talk about kind of strategy for that. You might meet with the town council. And as long as that case is going on, the executive session minutes of those meetings can be withheld, even if somebody asks for them. But when it's done, the board is supposed to, if they haven't already, they're supposed to go through, finalize the minutes, and unless there's certain aspects of them that there might be an exemption for, again, those minutes are going to become public. And again, some boards are better than others at keeping up on that. It's not because you don't deal with it at your normal open meetings. Sometimes executive session minutes can get forgotten a little bit. You should try to keep up on them. The law says the chair should review such minutes at reasonable intervals to help figure out, well, is this one done? Should we finalize these and make them available? Or in fact, is this still an ongoing issue? Although I'm not going to get too much into the public records law, there is an ability to charge employee time, hourly time, to do certain larger requests. But the time spent going through and examining executive session minutes cannot be charged because that's actually mandated by the open meeting law anyway. Just a couple there. The AG's office turns out actually several decisions a week now, so it's getting kind of hard to even keep up. But some that we would just point out are that all meetings have to start in open session. The only way you can have an executive session is to open your meeting in open and take a vote to go into it, because you need a majority vote of the board to go into executive session. A year or so ago, the AG came out and said, we understand that boards might have a one-topic meeting in executive session. We're going to meet with town council to talk about this case, Smith versus Planning Board. And that's all we're going to talk about, so why should we even What difference does it make if no one's going to be able to listen to this meeting anyway? The AG said that because you have to open an open session, if not count a meeting, you should actually put one, convene an open session, 2, executive session to discuss strategy for Smith versus Planning Board. That was not something we anticipated, but the AG has said that, and so we've tried to pass that along to folks. As I mentioned, requests for meeting minutes, you need to respond promptly. If an executive session is ongoing, you can just respond that those are not public because the open meeting law declares them not to be at that point. And another issue under the open meeting law, which again I won't get into beyond this, is email. You have to be really careful using email. It's so convenient to send around, whether it's draft minutes or here's a letter we got from our consultant. It's very handy to send around the packets for your next meeting, but you have to be sure that you're not exchanging opinions between a quorum of your board, because if you do, that's considered a violation of the open meeting law. So even if one member sends out something to the other members talking about an application and what he or she might think about it, that's considered a violation even if nobody writes back, because it was shared with a quorum of the board. So never hit reply all, if at all possible. So we'll talk a little bit about public meetings themselves. I've already talked about the open meeting law requirements. There may be other requirements. Oh, I'm sorry. Yes.
I just want to make sure I understand the part about the email. If one member of a board sends out, for instance, a contract to be deliberated upon at the next meeting, but there's no commentary or no opinion expressed, just the piece that people will be looking at, does that constitute an opinion?
It doesn't. Thanks for asking that. I'll clarify that. The term deliberation is defined in the open meeting law, and it excludes things that are just about setting up scheduling. You may want to ask board members, is anybody available next Thursday for a meeting? And it also excludes distributing documents. It's really specifically towards email. So if that's, you get a consultant report, you got a copy of a new application you're going to look at, those can be distributed, and that's fine. But the AG does have some opinions that said, well, when the chair sent out that application to all the members for the next meeting, that was fine. Then when the chair said, see, this is the kind of problem I knew we were going to have, then you start slipping into opinion. So it's an exchange of opinions on board business, really, that you don't want to do. Okay. But just distributing draft minutes, and copies of any documents, you're fine on that.
Okay.
Okay.
That's very good. Thank you.
Right. So we'll talk about meetings are generally either just sort of meetings where you're doing your business or a public hearing, which there are some differences. So a couple things about hearings. There are 3 main types. One is called adjudicatory. We get that from the courts. And that's typically where you are kind of going to make a ruling on someone's rights, whether or not they can do what they want to do in the context of whatever laws or bylaws or regulations that your board oversees. Dog hearings, you get a complaint about a dog. Well, are we going to make the person put up a fence or not? Personnel, disciplinary hearings are also considered this type. Then you have the kind that have to do with licenses and permits, liquor licenses, special permits, or maybe variances for zoning or planning boards. And then a regulatory hearing, which is generally just if you're going to adopt regulations or fees, make some changes to that. That may be also another one where you're required in some cases to hold a public hearing and take comments in from the audience. In general, under the open meeting law, it says for a meeting as opposed to a hearing, you have to allow the public in to listen, but they never have the right to participate unless the chair recognizes them. When you have a hearing, obviously, perhaps if you have a liquor license application, for example, you have to hear from the applicant, of course, but you're also, if it's a brand new license, you also have to give written notice to the abutters. Well, it wouldn't make sense not to allow the abutters to, voice their opinions as well. But in a general meeting, that same right isn't there. It's just the public can listen, but they not necessarily can participate unless they're invited to by the board. So as far as when meetings are conducted, this first one, is this how you want to be remembered for posterity? That's a little tongue-in-cheek, but again, if you've been on a board for a while, things can get kind of crazy. You might get some audience members who are very heated up about some topic. It is important for your board to be able to get its business done effectively, to try and rein things in as much as you can, and you are in the public spotlight, so it's important to try as best you can to handle those situations and get your board business done and get on with it as kind of objectively and passively as you can. If a meeting really goes south, the chair does have legal authority to cause someone to be removed, but there's a lot of caveats for that. First of all, who's going to remove them? Are you literally going to call the police department to have someone come over? And also, we have seen cases out there where someone has been ejected from a meeting and they turn around and file a civil rights action saying their rights to free speech were infringed on. Well, there might be defenses to that. It may be that they weren't recognized by the chair, but they just completely disrupted the meeting. But it's not a path you want to go down if you don't have to. So if you find yourself with a meeting kind of getting out of control, maybe taking a 10-minute recess is better. Try and diffuse the situation a little bit. And it also helps if, and again, sometimes an application for something comes in and it really catches the public's attention, and you get one of those packed meeting rooms. It's helpful to make sure that everyone who's there understands, this is what we're being asked to do. This is the bylaw we're operating under. This is the board can deny it, approve it with conditions. I think it's good to let people understand kind of the nature of what's going to be happening before you start. That may also help kind of keep people under control a bit. And it's important if you're a board that makes any kind of decisions, issues permits, not to dwell on litigation, which I have to, but the idea is to avoid it if you can. So it's important to make your decisions good so they'll stand up if they are challenged. Make sure the advertising requirements for that hearing are complied with, whether it's in the general laws, your local bylaws, or maybe the planning board has regulations on particular advertisement requirements. Make sure those are all taken care of. Boards kind of do public hearings differently, and there really isn't an invalid way to do it, but we usually recommend that you open the hearing, hear from the people you're required to hear from, perhaps recognize other people in the audience who might want to weigh in, and then when you feel you're hearing everything that both sides want to put in, close the public hearing. And at that point, the board is the only ones who have the floor. They're the only ones who have the right to talk about what they just heard, look back over things, have your discussion, and when you're ready, take a vote and make a decision. Once the public hearing is closed, no new information can come in. And that also, helps kind of preserve the integrity of the decision, that everyone knew exactly when all the information was in, and at that point it's just the board using its discretion to make a decision. Certain decisions have to be handled in a particular way. You may have to send by mail to the applicant, even though they may have been sitting there. I'll use liquor license again. You have to send them a written decision because that triggers their appeal rights. It may have to be filed with the town clerk. Again, zoning and planning decisions always have to be filed with the town clerk within a certain period of time, so make sure that happens. Advertising, again, that's very important. You want to make sure the application is complete before you start. Sometimes people have left out whole sections, or they haven't filed plans, which you're going to need before you can start dealing with it at a public hearing. Best to deal with that with the applicant before you actually open the hearing. Notice. Let's see. Oh yes, the last one there. Just so you're aware, if you do issue some kind of license or permit, if your board does, one option, sometimes you might get an application from someone who's kind of a tax scofflaw, shall we say. They're behind in various taxes or town fees. This bylaw, Chapter 117 of the town's general bylaws, which is taken from this statute, says that the treasurer can maintain a list of property owners or businesses that do owe these kinds of charges and distribute them to the licensing boards. And the statute and the bylaw that's under it actually says you can deny or even suspend or revoke in some cases a license or a permit if those things are unpaid. You have to allow the person to enter into a payment plan depending on how much they owe. But that's just something to kind of keep in the back of your mind if you find yourself dealing with an application and you know this person really owes the town a lot of money. Sort of an additional collection possibility. It's recommended, again, it's not strictly required by law, but we recommend to read the legal advertisement aloud. That way it's part of the record, it's part of the recording if it's being made. There's no question that the advertisement was made. You can say when it was published in the newspaper, if that had to happen. Make sure the board has a quorum. That's important because you can't do anything without a quorum. And there are certain things, again, typically with zoning and planning, where you actually need a supermajority to approve something. Certain special permits require 4 yes votes out of a 5-member board. So you don't want to start that hearing if you only have 3 members because you don't even have enough to make the decision. Talking about your procedures to the public, kind of mentioned that before. And so the public also understands what they're being asked, what you're being asked to approve. Allow the applicant to make their presentation. That's when the board members can ask questions of the applicant. Allow public participation. Again, that's within the discretion of the chair, because unless you're someone who got a butter's notice, for example, you may not have a right to address the board or to ask questions, but the board may want to encourage that as well. As I mentioned, when you're conducting a hearing and you've heard from the neighbors, you've heard from the applicant, you've asked questions of the applicant, and you've gotten everything you need, then it's time to close the public hearing. You don't need to take your vote while the hearing is still open. It just kind of keeps it cleaner, we think, to close the evidentiary part of the hearing, we call it. It's just a majority vote to do that. This is really just kind of a procedural matter for the board. And at that point you have your discussion and then you can vote on whether to issue the license, whether to put conditions on it. And again, make sure you have the proper quantum of votes, if it's a majority or a supermajority. so that the decision is valid. One thing we see in minutes, or sometimes if we're at a board's hearing and somebody makes a motion to approve an application and it fails, some boards like to go back and get a motion to deny. Strictly speaking, you don't have to do that. If a motion to approve fails, it's just deemed denied. And let's see. Oh yes, this example is from a zoning bylaw example. You want to make sure that your decision has enough in it so that someone looking at it can understand not just what you decided, but the reasons behind it. And that's important, particularly with a denial, let's say, that might get appealed. If it does end up before a court, the court's going to look at it and say, well, this just says the project would not be substantially more detrimental. Well, what does that mean? What did the board talk about? And typically what will happen is the court will kick it back to the board and tell them to start the hearing all over again. And so you don't want to do that. So this example is if somebody's trying to expand a use that might be non-conforming, the board has to find that it's not substantially more detrimental to the neighborhood. But again, you don't want to just say that. You want to explain why. Avoiding litigation, always good. Again, I'm saying this over and over again, but it is important, and things do get, things do slip by. That's life. But make sure that the advertising and the notice requirements happen. The board had enough people there to actually act on it. Make sure you take the proper vote at the right time. If you unfortunately do get served with a lawsuit, don't take it personal. They're just appealing your board's decision. But there are really strict deadlines that the court will look to. So if it lands in your board's office, it's important to know when you got served. Sometimes you may have a constable come in and serve it, but there are when a municipality is getting sued over something, a lot of times sending it by certified mail to the town clerk's office is good enough. So you need to be careful. You need to know on your board when this got served. Was there a summons attached to it? If there is a short order of notice, that's a particular summons that says, not only are you being served and you have to file an answer in 20 days, but there's going to be a hearing in court in 3 days because the plaintiff wants a temporary restraining order or an injunction or something. Obviously, those are even more important for you to know about. Regardless of what your board is, let the town administrator's office know so they can keep in touch with town council, and we can make sure that things that have to happen happen at the right time. Jumping around a bit, but this is another open meeting law issue. Sometimes your board may be involved with either inspections, or you're giving a permit that has something to do with the real property. Conservation Commission, Zoning and Planning, Board of Health. All those boards are often asked to do things or enforce things on a piece of property or a building, and you want to go out and look at it and see if you agree with what the situation is, or are there conditions we want to talk about. And so if the board can do that, the entire board can do that. This is another exception to the definition of meeting in the open meeting law. It's not considered a meeting if that's what you're doing, an on-site inspection. But you can't, while you're on the property there, start deliberating. This is an important exception because if the board's all walking around through a private building, you can't very well invite all the public on. That wouldn't be fair to the property owner. But at the same time, what the on-site inspection is for is to kind of look around, maybe ask a question or two of the property owner. I think that's okay. But then don't start discussing the application there. You need to kind of take your notes, take your visuals, and then at your next posted meeting, that's where you talk about what you saw and share opinions with each other. It is possible. Oh, yes, sir.
On the Conservation Commission,
looks better.
Okay, so I'm Mike Turgeon. I'm on the Conservation Commission. When we're out and we're checking our delineation, can we make corrections to the delineation? Or do you have to take notes and go back and do, because that could get really...
Well, I'll just tell you, like I always do, this is how the Attorney General's office would look at it. If they happen to get a complaint about that, they would say, you know, going on doing an inspection on a site is okay, it's not a meeting, but if a quorum of the board starts exchanging opinions about something, that's a problem. That's what has to happen at a posted meeting where the public is allowed to be there and to listen. So, I mean, I guess it kind of depends on a particular situation, but if you look at a delineation and you think, or maybe you might even be a difference of opinion about it, you kind of have to take your notes and wait till you conduct the meeting. So it may be that it's something really tiny and, you know, one member can point it out and the person or the consultant can say, yeah, that's correct. You know, not really a big deal in that case. But if anytime you get a quorum of a board exchanging opinions about something which is before them, it really is required to be done in a meeting. Okay? Okay. I already said this, but we like to repeat it. Don't deliberate via email. You know, again, what has to happen in an open meeting that the public has notice of and the right to be there is anytime there's deliberation between a quorum of a board. So if two members of a 5 or 7 member board are kind of emailing back and forth, well, here's what I think about this, you know, well, no, I disagree because this. Technically, that's not a violation because it's not a quorum involved. And if a quorum never gets involved, you don't really have anything to worry about. The problem with email, of course, is all of a sudden somebody forwards it to another member and say, well, here's what Bill and I think about this. So you just have to be very careful of that issue all the time. As I mentioned, scheduling is fine. Distributing materials via email is also fine. That's not considered a meeting. A couple things about public records. The default under the law is that all records made or received by a governmental body or official are public records unless there's a particular exemption. There are a lot of exemptions out there. A lot of them are contained in Chapter 4, Section 7, the definition of public records. And then there's a lot of particular statutes that exempt certain things. You know, Corey exempts people's criminal records from disclosure. But you know, 99% of all the records that you have, that you create or that you receive are going to be public, so you need to be careful with that. Emails are also public records, unless there's an exemption. So be aware of that anytime you're emailing each other on board business. The minutes, except for executive sessions, which can be withheld at least for a time, minutes are always public records. And the documents that were used at the meeting, as I talked about earlier, are going to be public. There may be certain exceptions, but you should always figure that everything's going to be public, and be careful how you handle it that way. Record retention. If you have administrative... Oh, I'm sorry. Yes, sir.
Thank you, Brian. If you're aware that there are documents that should exist because they're not allowed under the records retention law to have been disposed of, what obligation do you have to chase that?
There isn't any legal obligation on, let's see, one official who realizes that documents are being disposed of. There is a criminal statute. I can't give you the citation off the top of my head, but it can be enforced as a crime to destroy public records government records unless it's been authorized. But the law doesn't have imposed that kind of obligation, kind of a whistleblower obligation. It's really similar, I would say, with the conflict of interest law, which, as any town official or employee or board member, if you do certain things, it's a violation of the conflict law. And that individual can be subject to enforcement by the Ethics Commission. If you, as also a public official, are aware that somebody did something, there isn't any actual obligation to turn them in or make a complaint to the Ethics Commission. There's a complaint process for that, but you're not doing anything improper by not turning them in. I guess that's the best answer I can give you.
Thank you.
Okay. Record retention. There are certain things that are found in the general laws, but a lot of them have just been developed as a policy or a regulation by the Secretary of State's office. Secretary of State's office oversees the public records law. And so there's all kinds of different retention retention requirements. Anywhere from, if it's a kind of an administrative notes that you had or draft minutes, for example, once you've got your final minutes, you can throw the drafts away. There may be certain administrative things which once they've served their administrative purpose, you don't need to save them anymore. And then there's everything from you have to save it for a month, you have to save it for a year, 7 years. Meeting minutes must be preserved permanently. And right now, the requirement is also that they have to be preserved in paper form. More and more things are being, created and stored electronically, but at least for now, meeting minutes always have to have a paper copy, and they have to be preserved permanently. Most records that don't fall into a particular time are usually 7 years, and you're not supposed to dispose of them unless the Secretary of State's office has a different division, not the Public Records Office, but a different one where you can fill out a form, list various kinds of records you have, how old they are, and ask permission to dispose of them. That used to be a really big deal before electronic records because, your poor town hall vault would start bursting at the seams, and it was important to get rid of certain things if you could and didn't need them anymore. Now with electronic storage and cloud storage and that kind of thing, the physical space isn't quite the problem it used to be. But you are still required to keep these records as long as the retention schedule requires it. And you can look on the Secretary of State's office if you're curious about particular records in your office. They got a great long manual, and you can look up pretty detailed examples. Just briefly on the public records law, your board may get asked, you may receive requests, somebody wants a copy of something your board used or minutes or a consultant report you had 6 months ago, whatever it might be. Requests can be made orally or in writing or by email now. We see that more and more. Somebody may actually just want to say, I'd like to look at your meeting minutes from 2015. I don't want copies of them. I just want to be able to read them. That's a valid records request as well. You just need to kind of set it up with them so you can be sure that they're not going to do anything funny with them because you have to keep an eye on them. But they can also get copies of anything that's not subject to an exemption. Starting January 1st, when the new public records law kicks in, if you get a request, you have 10 business days to respond. That similarly does not count weekends or legal holidays. If someone doesn't think they got the response they needed, or they think you cited exemptions that shouldn't apply, they can appeal that to the Secretary of State's Public Records Office. There's a supervisor of public records is one of the officials in the Secretary's office who oversees these. As I say, you can charge employee time for large fees. A lot of times if you're just giving them a couple pages of minutes, it's really not worth it. Paper copies, you can only charge 5 cents a page, so again, if it's 10 pages, is it really worth demanding your 50 cents? You can decide that, I guess. If you're going to charge a fee and it's going to be over $10, you need to provide an estimate to the person in writing, and also explain that if you're going to want to charge employee time, it has to be the lowest paid person who can do the search. The new public records law is making some real changes to this. It can never be more than $25 an hour regardless of what that person's salary might be. And there's also limitations for towns that are under 20,000. You can only charge for employee time if it takes more than 2 hours to respond. If it's an hour or an hour and a half, you can't charge the employee time for that. A lot of changes. We've sent out some things to the Selectman's office on that, and I'm sure will be more because we're waiting for new regulations from the Secretary of State's office too. So I think this is about the end. This is practical advice, not legal advice, but again, we're just trying to hit some of the points of, so your board will do things efficiently, get to everything you need to, don't get to things you don't need to. It's important for boards to get their business done by having a quorum show up. It's always a problem if you end up with a board that is having trouble doing that. As you can be as familiar as you can before the meeting starts with what you're going to be asked to do. Look to facts, particularly if you have an application for something. You may not need to know why the person thinks this is a great idea and needs to happen, but this is when you conducting your hearing, this is when you can ask them, and get all the facts that you can base your decision on. Be patient with people. A lot of people come before a board and they're nervous too. They've never applied for a special permit before. They don't really know what it's all about. They don't understand what they're supposed to be conveying to you to help you make your decision. Don't make it personal. You're performing a government function here, and as I say, you just need to try to do what you need to do within your jurisdiction. Treat people equally. Try to help keep the people in the audience from creating arguments. Limit who can participate, because again, only certain people really have the right to participate. Ask questions of them, summarize what you may have heard, make sure you are getting what the applicant wants to convey to you. Be conscious of body language, especially now that we're all on TV all the time. And be open-minded. Those are, pretty self-explanatory, but it's easy to have something before your board that triggers strong feeling for you, but you do have an obligation to, treat objectively. If you don't, that's one issue that can be raised in a court challenge, for example. Let's see, is that the end? That is the end. So I'll be here for a few minutes if anybody wants to follow up with anything, but hopefully this was a little helpful. Just in case you're curious, we do like to provide a training like this once or twice a year to our municipal clients. We don't charge for it, so you don't have to worry about keeping me after if you wanted to talk about something. And I appreciate you coming out on this awful night, so thank you very much.